So good evening and welcome to Tecumseh's Committee of Adjustment meeting for the month of August in 2024. Everyone is here except Tom, who has called in and said he'll be 15 minutes late. So that's the attendance. And welcome to all of you. Is there any disclosure of pecuniary interest? Seeing none. Minutes of the July 22nd meeting were pre-circulated. Motion. Doug and Tony. Doug and Tony. Any question, addition, deletion, correction to the minutes? Seeing none, all in favor? Opposed, carried. Unanimous. You ready? The first application this evening is an application for consent with the Catholic School Board at 12050 Arbor Street. So if you want to come up, we need some chairs. We're not going to make you stand up. It's okay.
Thank you. Application for consent B0924 Windsor Essex Catholic District School Board 12050 Arbor Street. The purpose of the application is to sever a 3,454 square meter, 0.86 acre parcel of land currently used for parking, outlined in red on the sketch, described as Part 1, 12R 23883, and add it to the abutting commercial property to the north, municipally known as 12049 and 12053 Tecumseh Road, which is shaded in pink on the sketch, resulting in a total lot area of 0.67 hectares, 1.7 acres. The proposed retained parcel outlined in green, which contains a trade school, will have an area of 1.9 hectares, 4.7 acres. The proposed severance will provide additional land for parking for the commercial lands to the north. The lands subject to the application are designated Main Street mixed use in the official plan. The proposed severed and retained lands are zoned community facility in zoning bylaw 1746. The property to which the severed land is being added is zoned general commercial C3 in zoning bylaw 1746. The following comments were received. Public Works and Engineering Services. The applicant will be required to enter into and provide the town of Tecumseh a written agreement for the reapportionment of drainage assessment for the subject lands in accordance with Section 65(2) of the Ontario Drainage Act as amended, and that the associated costs of same be borne solely by the applicant. No comments regarding the application from the Building Department. Fire Department had no comments regarding the application. Essex Region Conservation Authority. The site is not located within the regulated area of the Ontario Regulations 41-24 under the Conservation Authorities Act. No objection to the application. Essex Power Line. Essex Power Line indicates they have an overhead secondary cable in the northwest corner of the severed parcel. Thank you.
Okay, thank you, Donna. At this point, I usually ask the proponent if they have anything they wanted to tell the committee that wasn't already.
No, thank you, Mr. Chair and committee members and administration. Frank Ciroli from Shibley Wrighton law firm here representing Windsor Essex Catholic District School Board. Here just to answer any questions that the committee might have.
Okay, thank you very much. Is there anybody in the audience that's here for this one? Is there anything you'd like to say?
Thank you, Mr. Chair. No, I'm Penny King from the Windsor Essex Catholic District School Board. Mr. Ciroli is representing us this evening, again, just to answer questions. So
Okay.
we are the applicant.
Good. Thank you. Any committee have anything to ask? Doug?
Through you, Mr. Chair. This would extract parking spaces from the original school, I'm assuming. How many parking spaces would be left for the school?
There would be a sufficient number based on the number of educators at that location. When I went through the development review process, that was one of the questions that they asked, and they wanted to make sure. So, Penny, do you know exactly how many parking spaces? But I know there would be sufficient number for the number of teachers there.
Through you, Mr. Chair. Do you see that school growing in numbers where the students would need parking spaces and then would have to park out onto the streets, or is there enough that would suffice when what you're asking?
Thank you. So for the question, so I don't know the exact number of spaces left. I know that the severed portion represents about 112 spaces, but we have been assured and verified that even with growth, the remaining spaces will be sufficient for the needs of the facility.
Enrico, I saw you nodding your head when the question was asked. Do you have a comment with regard to whether the remaining property will still meet parking as per the bylaw?
Thank you, Mr. Chair. We don't have the precise number either, but we did do an analysis and it met the requirements of the zoning bylaw. Yeah.
Good, that's good to know. Thank you. Any other questions? Lori?
Thank you, Mr. Chair. A question for administration, or rather just a statement. It did clarify a question that I had about what happens to the split zoning or the split OP designation once the severed parcel becomes added to a commercially designated parcel. So just for the record, can you confirm that as a part of the town's upcoming new municipal wide zoning bylaw, the community facility zone land, so those parking lot lands, will be added to the C3 lands and essentially will be rezoned as a part of that project?
Thank you for that question, through you, Mr. Chair. The property is designated in a mixed use Main Street designation, the entirety of the property, including the lands that are to be added. But it does have a split zoning, and that split zoning will be addressed through the new zoning bylaw. Okay, it doesn't create any complications for this lot addition. And back to the the question regarding parking, Mr. Chair. Part of the reason we don't have the precise number is we did an estimate based on measuring the areas in which parking is allocated now. It's not striped according to the airflow. It's not striped well, so it's difficult to do the count. But just based on the minimum parking dimensions in the bylaw, it well exceeded the minimum number required.
Okay. Lori, again?
Thank you, Mr. Chair. Just a question to the applicant. So what will happen with the existing agreement between the two parties once the land is added?
I believe what would happen with the license agreement, once title will be transferred, if title is, if we can reach an agreement with the abutting owner and title is transferred, that license agreement would have no effect in law.
Thank you once again, through you, Mr. Chair. So do you have, I guess, is there, or would that be a condition of your lot addition or your severance to sell to that landowner?
That's our hope, is to reach an agreement with the abutting owner who was a successor in title to the old Torino's restaurant back in 1987 when the agreement was signed between Torino's and the school board.
So to administration, I guess the question would be, if there is no purchase, then what would happen with the lot addition application today before us?
Sorry, through you, Mr. Chair. The proposal is to sell the parking lot to the commercial plaza. So that agreement that currently applies to that parking lot would have no stand. I'm not sure what the legal terminology would be, but it wouldn't have any bearing or relevance any longer.
To clarify, not the agreement, but what happens to the application before us for severance if the adjacent landowner does not want to purchase the parking lot?
Mr. Jeffrey, can I make a quick comment? I think in that case, what would happen, we have 2 years, if the committee grants us our request. In 2 years, if there is no, transaction completed, this decision would lapse and we'd have to start the process over again.
Sounds like they're assuming that it will be a condition that the property be sold to the adjacent owner. We don't want to have a landlocked piece of property sitting there.
Yeah.
I believe
So,
it's
Mr.
already a
Chair,
condition, Mr. Jeffrey.
That's correct. So there is a condition that it's subject to 50 sub 3 or sub 5 of the Planning Act, which means that land would glue to the abutting lands that are owned by the commercial plaza. So my apologies. I understand the nature of the question you were asking now. But yeah.
You good?
Through you, Mr. Chair, I feel confident bringing this application for consent forward for a vote to honor it.
With the conditions as laid out in the planning report.
Thank you, Mr. Chair and committee, and to administration for your assistance. Okay.
So could I just get you to turn the mic off while she's reading this? Thank you.
Application for minor variance A 2324, Julia Germani, 202 St. Pierre Street. The purpose of the application is to request relief from the following subsections of zoning bylaw 1746. Subsection 7.1.5 establishes a maximum lot coverage of 30%, and subsection 7.1.10B establishes an exterior side yard width of 5 meters, 16.4 feet. The applicant is proposing to construct 178.2 square meter, 1,918.13 square foot, single detached dwelling, resulting in an exterior side yard width of 3 meters, 9.8 feet, and a lot coverage of 31% as depicted in the sketch. The lands are designated residential in the official plan and zoned R2 in zoning bylaw 1746. The following comments were received. Public Works and Engineering, no comments. Building Department, no comments. Fire Department, no comments. IRCA, the lands are subject to the regulations under the Conservation Authorities Act. The parcel falls within the regulated area of Lake St. Clair. Their office previously issued IRCA permit number 401-23 for this development dated August 4th, 2023. However, this approval has expired and a new approval is required prior to any construction or site alteration or other activities affected by Section 28 of the Conservation Authorities Act, and all applicable hazard lands requirements for development must be satisfied. No concerns with the application. Essex Power Lines. The customer is to contact Essex Power Line if they require changes to their electrical service. Thank you.
Okay, thank you, Don. And you are? Oh. Always bring Dad. Yeah. Thank you. Is there anything you'd like to add for the committee to consider? Okay, okay. Anybody else in the audience on this one? Not? Committee have questions? Lori?
Seems like it's a very straightforward application. What we do is we review the application against 4 tests under the Planning Act, which I'm sure the planning team has provided you with some information on. A question to administration, or maybe you might know, what was the previous house's lot coverage? It doesn't seem like this particular lot coverage is that much of a difference, but just wondering what the previous lot coverage used to be.
It's only 1% greater than, it's 30%. The proposed house would be 31%.
To clarify, the prior dwelling.
Oh, there were 2 buildings on that property. One was, we purchased, or sorry, my daughter purchased it. The other daughter owns the other lot. And that house straddled both properties. Then there was a house prior to that was demolished prior to us purchasing it.
So to clarify, does anyone know what the prior lot coverage was? Was it over 30% at the
Well,
prior time?
I know the setback was a lot closer than what we're asking. I don't know the exact lot coverage, but the little house that was on there when we purchased it was approximately 800 square feet.
Yes.
20%.
Through Mr. Chair, it was approximately 20%. We don't have the exact figure, but based on, tracing the building outlines, both buildings on that lot, it's about 25%.
So the intent of my question, Mr. Chair, and through you to the applicant, was to determine what is the difference from what was covered in terms of lot coverage in the past to what is being proposed. Understanding that 30% is the maximum in the regulation, and certainly understanding that your proposal is not asking for a huge variance, but a minor variance. Thank you.
Anybody else? Anybody else? Welcome, Tom. Nobody else. How about a motion then? Are we ready for Paul?
Through you, Mr. Chair, since this obviously meets the 4 tests and is minor in nature, I'd like to make a motion to pass application A2324 202 St. Pierre Street. I believe there's any regulations.
No. Okay. Seconded by Chris. Just so you know, there were a bunch of things read out from ERCA
Yeah,
and
we're aware of those.
and Hydro, so they're not gonna be conditions, but they're things you'll have to deal with.
I understand the regulations of ERCA,
Okay,
or she does too.
well, she's one then. Okay. There's a motion on the floor, all in favor? Opposed? Carried.
Okay, we're done.
Thank you.
Thank you.
Next, we have 1614 Les Brunch. Fairlane Developments. Who don't appear to be represented at the meeting. Get off of that phone. Gee.
I just didn't recognize the address.
Oh, okay. Go ahead, Don.
Application for consent B 1024 Fairlane Developments, Inc., 1614 Les Bronx Road. The purpose of the application is to sever a 2.45 hectare, 6.05 acre vacant agricultural parcel of land outlined in red on the sketch described as Part 1, 12R 25167, and add it to the abutting agricultural property to the east, which is shaded in pink, resulting in a total lot area of approximately 10.029 hectares, 25.44 acres. The proposed retained parcel outlined in green, which contains a commercial plaza and a daycare, will have an area of 3.1 hectares, 7.55 acres. The proposed severance lot addition is to facilitate the consolidation of vacant lands within the Tecumseh North settlement area in preparation of future development in accordance with the existing land use designations of the official plan. The lands subject to the application are designated general commercial and residential in the official plan. The proposed severed lands are zoned agricultural A-33, and the proposed retained lands are zoned general commercial C1-2, holding general commercial H C1-2, institutional zone I, and holding residential zone H R1 in zoning bylaw 85-18. The property to which the severed land is being added is zoned agricultural A-33 in zoning bylaw 85-18. The following comments were received. Public Works and Engineering Services. The applicant and future owners should be made aware that future property amendments may be subject to the site plan control process, under which Public Works and Environmental Services will work with the owners and its consultants regarding site servicing, stormwater management, traffic and planning studies. This includes, but is not necessarily limited to, submission of site servicing and grading plans and stormwater management reports that capture the proposed amendments for Public Works and Environmental Services review and approval. The applicant should be made aware that the subject properties are within the watershed of the existing municipal drainage systems and may be liable for the costs of assessments relating to future works or improvements or maintenance in accordance with the provisions of the Ontario Drainage Act. The applicant will be required to enter into and provide the town of Tecumseh a written agreement for the reapportionment of the drainage assessment for the subject lands in accordance with section 65(2) of the Ontario Drainage Act as amended, and that the associated costs of same be borne solely by the applicant. Building Department had no comments. Fire Department, no comments. IRCA's comments are as follows. The noted lands are subject to the regulations under the Conservation Authorities Act. The parcel falls within the regulated area of the Sear Drain and Extension. If any new construction is proposed, the property owner will be required to obtain an approval from IRCA prior to any construction or site alteration or other activities affected by Section 28 of the Conservation Authorities Act. They have no objection to the application. The County of Essex. The minimum setback for any proposed structures for the proposed adjacent, for the property adjacent to County Road 22 must be 26 meters from the current property limit. Permits are necessary for any changes to existing structures or the construction of new structures. No access is permitted off County Road 22. The county requests to be consulted once properties have proposed development. They're requesting a copy of the decision once decided by the Committee of Adjustment. Also, should these applications be approved, they are requesting a copy of the revised survey plan of the subject lands in order to update their mapping system. Essex Power Line, no comments as the area is outside the Essex Power Lines service area. Thank you.
Okay, you want to introduce yourself?
Good evening, Mr. Chair and Committee. I'm David Petretta. I'm acting as agent to the applicant, Fairlane Developments, and I'm also the beneficiary of the severed lands if this is successful tonight.
Is there anybody here on this application in the audience? Seeing nobody? Committee have questions?
Through you, Mr. Chair, there was quite a bit to digest, so I'm gonna look to administration to kind of break it down for us.
Mr. Chair,
Chad?
it would take some time to break down all the, the elements of this proposal and what's behind the scenes. We've been meeting for many months. Essentially, what this is doing is consolidating the lands to facilitate the future development of the lands in red. So currently, there's an awkwardly shaped parcel that includes the area outlined in green on the screen. And that will remain, the retained lot will remain one lot. There's a bit of a break in this. So the lots on both the south and north side of Westlake will be one lot. And the red is being consolidated on the south side of the future extension, Sylvester Drive to Westlake. The south side of that will become residential development. And there's a number of planning steps that the landowner and proponent has to go through before anything can develop there, including a site plan control agreement with municipality, which will include many provisions related to the servicing of these lands and to access and extension of roadways and that sort of thing. So this is the initial step in a long process. But it's, the municipality is excited about this, and it's a positive first step. So tonight it's simply consolidating the lands in order to facilitate the future development of the lands in red.
Thanks, Chad, for that. So just further to that, you mentioned road extensions. I assume that the long-term intention is to extend Westlake through these properties?
Yes, through Mr. Chair, the long-term intention, if you can follow my cursor on the screen, is to extend Westlake through, and it follows the northerly proposed lot line to Sylvester Drive. So it'll connect to Sylvester Drive there.
Thank you.
Go ahead, Lori.
Thank you, Mr. Chair. Through you to administration. So in reviewing the report, just to clarify some things in my mind and to Doug's point, it's a big vision. So just want to make sure we're all on the same page here. So the zoning currently is agricultural, but the town's official plan deems or designates the property, and we'll call it a split designation, commercial fronting County Road 22, and residential, we'll call it south of the future Westlake. So to confirm, the intent here is to have, I see both. It sounds as if there will be a site-specific zoning bylaw amendment application, as well as the town-wide zoning bylaw that's going to clean things up in terms of zoning categories. Can we hear a little bit about that? And will the subject lands be placed in a holding provision to kind of facilitate studies related to servicing?
Yeah, if the committee would like to follow along in the planning report, you'll see under the Tecumseh official plan section, you can see the split designation, the commercial to the north of the future extension of Westlake, and the residentially designated land to the south of that. And so that's the 25-year vision for this area, for those to be the north of Westlake lands to be commercial, south of Westlake lands to be residential, and the form of that residential could take many forms and of different densities and different built forms and building types, and that will be determined through a rezoning process that they'll have to go through. So there's another public process that is part of all this to accompany the site plan control process that the applicant has to undertake. And through that site plan control and zoning process, the municipality will secure the necessary servicing and access, and including the extension of Westlake. Stormwater management is another issue that we've spent considerable time talking about. So all that will be tied up in the site plan control agreement that's forthcoming. And it'll likely be done through a site-specific rezoning. But because the site-specific rezoning and the new zoning bylaw processes are somewhat dovetailing at this point, it's possible that it gets incorporated into the new zoning bylaw, but I think it's probably going to go through a site-specific rezoning, given the interest in developing the lands as soon as possible.
Hmm.
And it will be, it will go into a holding zone until, all the necessary agreements are secured.
Thank you for that, Mr. Jeffrey. So just to confirm, the parcel that's, we'll call it the north or the future north piece, north of Westlake Extension, will be commercial, and that the commercial is not proposed to back onto existing residential.
Yes, that's correct. The commercial component will be separated from the residential component by the extension of the municipal roadway.
Any other questions? Anybody else? Anybody else? Got your work cut out for you. Okay, if there's no more questions, can I get a motion from the committee? Laurie,
Thank you, Mr. Chair. The application before us for lot addition, it's evident that it meets and is consistent with the provincial policy statement, the County of Essex official plan. But after further review and discussion tonight, I'm very content that the application is consistent with and meets the intent of the town's OP as well as the zoning bylaw. And for those reasons, I do move to approve the application with the recommended conditions as identified in the planning report. Thank you.
what about it? Doug or Tony, take your pick. Tony. Okay. We have a motion on the floor, all in favor? Oh, carried. Unanimous.
Thank you very much.
Okay.
Have a good night.
Where are we? 111 Hayes.
Application for minor variance, A 2424, Brett and Andrea Palmer, 111 Hayes Avenue. The purpose of the application is to request relief from the following subsections of zoning bylaw 2065. Subsection 5.191C establishes that accessory structures shall not be closer than 1.2 meters, 4 feet to any lot line if greater than 32.8 square meters, 107.64 square feet. Subsection 5.19.1I establishes that for accessory buildings greater than 32.8 square meters, 107.64 square feet in area, eaves shall be allowed to encroach 1.2 meters, 2 feet, and eaves troughs and additional 0.5 meters, 0.5 feet into the required setback, and subsection 5.192D establishes that no water circulating or treatment equipment such as pumps or filters shall be located closer than 1.2 meters, 4 feet to any side or rear lot line. The applicant is requesting relief to construct a 14.3 square meter, 154 square foot accessory structure pool house a distance of 0.6 meters, 2.0 feet from both the rear and side lot lines, with the eaves and eaves troughs encroaching an additional 0.45 meters, 1.5 feet. The pool equipment to be housed inside the structure will be approximately 0.82 meters, 2.7 feet from the lot line. The existing accessory structure located at the southeast corner of the rear yard is being removed. The subject property is designated residential in the official plan and zoned R2 in zoning bylaw 2065. Following comments were received. Public Works and Engineering Services, no comments regarding this application. Building Department, The property shall retain its own surface water and not adversely affect adjoining properties. They're required to obtain permits for the proposed accessory structure and pool prior to construction. The fire department had no comments. Urcas, the lands are subject to the regulations under the Conservation Authorities Act. The parcel falls within the regulated area of the East Town Line Road drain and Lake St. Clair. However, as a proposed accessory structure is less than 15 square meters, a permit from their office is not required for this development. No objection to the application. Essex Power Line has no comments. Thank you.
Okay. And introduce yourself.
Good evening, everyone. My name is Brett Palmer. I'm the applicant for this minor variance.
The only question you might deal with, you can tell the committee if you've had any conversation with neighbors.
So I've had some direct conversation with my 5 closest neighbors. I've received signatures here. I can present that to the committee.
It's perfect, thanks.
None of those neighbors had any concerns when we spoke with them.
I'm going to ask another question, take my prerogative this year. There is a building on that corner right now. Does that come down, it's being replaced, or is that the building we're talking about?
So that's the plan, is to replace that building, is to remove that existing shed that is currently there
Yeah.
and to replace it with this pool house.
Okay. Committee questions? Others on the committee questions? Go ahead, Doug.
Through you, Mr. Chair. When I went on site, I noticed the entrance to your side lot is that where you're gonna bring in the digging, or is it coming around the back to dig that pool?
The current plan right now to dig the pool would be coming from the west entry of the lot, no, so not the east entry of the lot. There's a little more space on that side coming around that corner.
Okay.
Any other question? Any other question? Laurie?
Thank you, Mr. Chair. So just to confirm, with the noise mitigation, the pool pump is to be housed within the structure?
That is correct. Yes, we plan to keep all pool equipment inside the structure to mitigate any sound to the neighbors.
And it's worthy to note that most of the accessory structure will meet the 4-foot minimum setback. And seeing that there is, it's just an awkwardly shaped lot, that the accessory structure in its entirety complies for the most part. And it's worthy to note that just with that configuration, things are kind of awkward, and also forcing us to look at this odd regulation in terms of eaves trough encroachment. That's a new one for me, at least. I don't think I've seen that one here. So thank you.
We'll make a motion for A2424 that we accept it based on meeting all the tests, and also the fact that if you look in the neighborhood, this is a common type theme of pools in the backyard. So submit it for.
Okay, thanks. Seconder? Tony? On the motion, all in favor? Opposed, carried.
Thank you, everyone.
Welcome. On Riverside Drive, welcome.
Application for minor variance A2524, Jonathan Mueller, 12526 Riverside Drive. The purpose of the application is to request relief from the following subsection 6.1.11 of zoning bylaw 1746, which establishes that the midpoint of the wall nearest to Lake St. Clair of any new dwelling shall not extend beyond the established building line. The applicant is proposing to demolish the existing single-unit dwelling and construct a new two-story single-unit dwelling having a building footprint of 390.8 square meters, 4,207 square feet. The midpoint of the wall nearest to Lake St. Clair extends beyond the established building line a distance of 5.32 meters, 17.46 feet, as depicted on the sketch. The property is designated residential in the official plan and zoned R1 in zoning bylaw 1746. The following comments were received. Public Works and Engineering has no comments regarding the requested minor variance. Building Department, the applicant shall obtain a lot grading plan at the time of permit application for review and approval. Fire Department had no comments. IRCA, the above noted lands are subject to the regulations under the Conservation Authorities Act. The parcel falls within the regulated area of Lake St. Clair. The property owner will be required to obtain a permit from IRCA prior to any construction or site alterations or other activities affected by Section 28 of the Conservation Authorities Act, and all applicable hazard land requirements for development must be satisfied. They have no objection to the application. Essex Power Line. The customer is to contact Essex Power Line to provide their new electrical service needs. And I did have a conversation with the neighbor to the east with respect to the positioning of the house and how close it would be to Riverside Drive. Thank you.
Okay. So you've been here long enough, you know the routine.
Jonathan Mueller, I am the applicant and the owner of the property, and then with me is both neighbors, Mr. Stan Levesque, neighbor to the west property, and Miss Ann Proofer, neighbor to the east property, both directly abutting my property.
Good. And I assume they're here in support.
I believe they're both here in support. Stan Levesque has provided a letter, which I think is referenced in the staff report. And then I've met with Miss Proofer a few times to walk through this. And I would maybe just add that the positioning of the house and the property is, an effort, I would say, to compromise. We are fortunate that not only our three homes, but also further to the west as well, we all have relatively open front yards, which from a sort of a neighborhood safety perspective is important to all of us. And we feel like this compromise of having the porch area go past the line of sight is giving us much more safety. If you scroll up on the plan, you'll see that my new garage generally aligns with Ms. Proofer's garage to the east. And so without that, it would push my house further south towards the road and sort of box her property in. And so we felt like this was a good compromise between the three of us.
Good. Thank you for that. Is there anybody else here on this one? You gotta come up.
Well, just
so we can hear you.
a little concerned, it might not happen, but just hypothetically more, but possibly, who knows?
So your name and address.
And Proofer, I live in the house right on the east of John. Okay, so, well, well. Okay, so. All right, this is regarding the variance that Jonathan Mueller is requesting regarding the new house that he wishes to build on my west side. My main concern is that if the existing garage is moved from its current spot, that it does not extend more than 4 feet, say 4 feet or 3 or 4 feet southward towards the sidewalk of the town. If the extension is several feet southward, it would kind of box in my property and make it difficult for me to escape in an emergency. This could be, there could be a fire or a burglary. On the north side is the lake, offering little or no escape, especially if ice is covering it. So that's basically what I wanted to say.
I think that was essentially what you said in your conversation, Jim.
That's right. I think that the position of the house on the property now is a reasonable compromise to both the line of sight and addressing the safety concern that Ms. Proofer has raised. I don't know if you can see the dotted line on the drawing there, which is the existing property, correct? The existing garage and then the new garage.
Yep.
I can't say with certainty right now without scaling that off that it's 4 feet or 6 feet. It's not 20 feet. I know that. We can see on the side there's about a 5 feet setback that the architects marked there. So it's somewhere in that neighborhood of 6 or 7 feet. Certainly, if this is not approved, the house moves south 17.5 feet, which I think is the concern that Ms. Proofer has raised.
Good.
Pardon?
Turn the mic off, please, because it's hard to hear with it on. Okay, thanks. Anybody on the committee? Don?
I can see at the north edge of the proposed and the existing residence, it shows a dotted line where the house extends to now. The shaded portion of the new house, what does that look like? Is that an enclosed porch?
It's an open-sided porch roof and then 2 posts on the north side, if you will, but open on the east, north, and west side.
Okay, and the existing house, so as I said, it extends almost to the face of your proposed house.
Correct.
And
Existing house there is solid. I mean, it's the house. It's not porch or anything like that.
so in other words, it cuts off the view now. You're really not cutting off any view
Correct.
with the proposed house. And the intention is to always, to always remain open,
Correct.
not with retractable screens and or
Even with
glass.
retractable screens on the lake, they are only temporary. I mean, any wind, anybody who has them on the lake will tell you that you can only put them down in certain weather conditions. It's not like other parts of the town where there's more protection. You'll ruin very expensive screens leaving them down. So Ann and I have, Ms. Proofer and I have talked about that. I'm not sure if it's in the budget yet, but there's no scenario where there's a permanent screen in place. They're just the northeast winds on the lake ruin them.
Okay, thank you.
Any more questions? Lori?
Thank you, Mr. Chair. What does EQ stand for?
Where do you see that on the, equal? They're saying that the center line of because that's the way the bylaw reads, to the middle of the center line of the point through the line of sight. And so they're just showing that the porch equal sides down the middle is 17.5 feet from the line of sight to the edge.
Okay. And there's nobody else here on this one. Okay. That wants to speak. Okay. Any more questions from the committee? Paul?
Through Mr. Chair, to question to the applicant, the height of the rear porch, like off the ground, is there a couple steps down yet to the grass?
Right now, that's what's shown on the elevations. Certainly, I think the staff report noted, and it's understood by myself, that all of this is subject to IRCA approval. And IRCA will set a grade for me based on existing grades that are out there. And so whether it is 1 or 2 steps, I'm not sure. The only thing I can say is that, you know, the height of my main floor of the new structure is around 9.5 feet. So I expect the opening to be about 9.5 feet or a little bit more. Where that lands relative to the existing or new grade will be told to me by IRCA.
Yes, through you, Chair, just on the east side of the porch, is there a fireplace there?
There was in previous architectural plans, but I think it's been eliminated, and I believe that even the staff report, if it does not, it should say that it's an open-sided porch.
And as with so many of these other applications, there has been a lot of discussion on open-sided porches and then the later desire to put those removable or retractable screens and or other coverings. And as you noted, they probably have limitations when exposed to the lakefront. But I guess the concern is maybe from a bylaw perspective later on when people are complaining that their views are cut off. I guess that's more of a comment, maybe a
I can tell you, I have no problems if the committee wants to include a condition that says there's no permanent enclosures on the sides. It really would only be the east side. The west side would be no issue there, obviously, because it's the side of the house to the west. But again, I have no intent to do that. If it's anything, it's temporary screening. But Ann and I have spoken about that sometimes, to your point, these things grow and they end up with windows and heating and cooling. That's not my intent here at all.
right. Okay, thank you.
Any other questions? Okay, we satisfied ourselves. We got all the information. So is there a motion? Doug,
Through you, Mr. Chair, I'd like to bring a motion forward. And I don't know if we need to include what the gentleman said about the enclosure. Is that something we can? Okay, I would like to include that in the motion. Application for variance A-25-24, 12526 Riverside Drive, that be included in the.
did it be added as a condition?
Yes.
Okay.
Thank you.
Seconder, Tom? Any further discussion? All in favor? Those carried. You're good.
Thank you.
All right. Thanks very much for coming. And last but not least, 1690062 Ontario, 901 St. Pierre.
Application for minor variance A 26-24 1690062 Ontario Inc., 901 St. Pierre Street. The purpose of the application is to seek relief from subsection 7.1.1B of zoning bylaw 1746, which establishes a minimum interior side yard width of 1.8 meters, 5.9 feet for a two-story dwelling. The committee granted minor variance application A 18-22 in November of 2022 to permit a southerly interior side yard width of 1.22 meters, 4 feet for a two-story dwelling on the subject property. During an inspection of the dwelling's construction, an error was identified in the placement of the foundation. This will result in the dwelling having an interior side yard width of 0.89 meters, 2.9 feet, rather than the previously approved 1.22 meters, 4 feet. The property is designated residential in the official plan and zoned R2 in zoning bylaw 1746. The following comments were received. Public Works and Environmental Services has no comments regarding the requested minor variance. The building department, the applicant is to satisfy all OBC requirements with respect to spatial separation. Fire department, no comments. ERCA, the property is not within the regulated area. And this development does not require an approval from their office. No objection to the application. Essex Power Line has no comments.
Okay, thank you. And you are?
Good evening, everybody. My name is Andrew. I am the builder for my company, Stronger Homes, and I'm also the builder that's operating on behalf of my family that owns the property, which is the 1690062 Ontario Inc. number. Formally and firstly, thank you to a number of you because I've called a handful of you excessively for help on this and also just for advice. But outside of that, it's also an apology and a request for your help because of the construction error in the drawings in order to respect and follow the original minor variance that I pursued with the 4-foot side yard. The drawings were designed such that between buildings, if 4 feet one, I figured meet 9 feet, and then they would be grandfathered in, that I would by default satisfy that minor variance standard. But the benchmark that was poorly placed and a mistake on my behalf was that I didn't account for the fact that the previous house, which my family's company still currently owns at 905, is not centered on its own parcel. So while I've actually exceeded the space intended between buildings, and I'm closer to nearly 10 feet between buildings, because that one property is jogged further south, the distance from the property line is about a foot short of what it should be. And again, I apologize, that's my mistake. But when I called for concrete, I had just cleared with the surveyor that it was 9 feet, and I was confident with following up to the inspectors that that would have meant that I satisfied the original setback required. But when the report came in and it revealed that while I did meet the setback between buildings I had in mind, that the distance to the property line was about a foot short. Fortunately, we do own the neighboring lot, and in my panic after the mistake was made, I spent the better part of half a day driving around Tecumseh trying to see where other pre-existing similarities were. And after speaking with the building inspectors, subject to this being approved, if you are willing to help me, I can go into an agreement with myself and make sure that I satisfy any building code needs as far as glazed openings are concerned, fire codes. But that's the long and short of it.
Committee have questions? Doug?
Through you, Mr. Chair, I guess my first question I would have asked is, how does this happen? And my second question is to administration. The building inspector does not go out and inspect foundation before cement pour, and would he have not picked this up? And why was it missed? Or
Yeah, the building department had its suspicions that this was too close. They flagged it, but the pouring of the foundation went ahead. It's my understanding of it. It wasn't. It was flagged at a number of stages, but
through you, Mr. Chair, so there was notification, but prior to pouring or prior to ordering cement, that this location was not within the bylaw, correct?
not speaking on behalf of the building officials or for them. My understanding was it was just that there was a warning to be sure that the interior side yard measurement was taken from the lot line, from a surveyed lot line, as opposed to the other building.
Anybody else? Tony?
Through you, Mr. Chair, I guess my question would be either to the applicant or administration. The applicant has expressed that he is willing to enter into the agreement for the spatial separation setback for the glazing of the windows. How is that going to be registered on title now for the 905 St. Pierre? Or in this case, if that is the case, would it be easier to sever a foot of 905 and give it to 901 to make it meet that setback that we had granted?
So I think the applicant wants to weigh in on this as well, but I'm not sure what kind of discussions have taken place between the building department and the applicant with respect to that agreement. But I believe it would apply to the new house only. And that because there's an existing house to the south. I do understand that it can be addressed through, restriction in openings and the types of windows that can be constructed, but I'm sure the applicant can elaborate a bit on that. With respect to the severance option was discussed, it raises a number of other variance requirements in terms of lot area, lot frontage. And also there's a servicing connection that the building department thought would cross the lot line if that lot line was to be moved. So you'd have a servicing connection, a deep one, sanitary connection that would have to be relocated as a result at a significant cost. Yeah, and it doesn't, physically the buildings are where they're, if this variance goes through, the buildings are where they're at. Moving the lot line simply moves the future walkway or whatever associated with that building. They're still separated by that 9 feet.
So in response to your initial comment, Doug, as for how the mistake happened, I by verbal confirmation when I had the inspector there, first and foremost, I had Pete come by, and when we were excavating, we had exposed the sanitary to 905. And at the time, I didn't realize that his concern was the distance to the property line as much as his concern might have been where the sanitary was. However, that's a separate issue just to kind of reference when one of the flags was brought up, and I didn't realize that's what he was concerned for at the time. But as far as how it happens for the pouring of the concrete, we had the forms set up, and again, just referencing the prints, thinking that the distance from the abutting property would have inherently satisfied the setback. I had confirmed with the surveyor, I'm like, am I 9 feet from this house? Because on the blueprints, that would have meant that I satisfied it. And I said, he told me you actually are further than 9 feet. But again, the mistake was that I shouldn't have been measuring from the house at all because the oversight was thinking that it would be centered on its parcel and it wasn't. But because he told me I exceeded the 9 feet from the property, there was a relative degree of confidence that once the paperwork came due, that it was going to show as per the setback certificate that it was all fine, but I was some 1 foot short on that. And that's why that happened. As per your question about severing it, I wondered the same thing as well. But after speaking with Donna and Chad, they informed me that there is some can of worms to be opened with that pursuit that's not favorable. And a minor variance is the easier way to go about pursuing the solution for this. And as far as going into an agreement with myself and referencing where respect for building is so that you can still satisfy concerns for glazed openings and whatnot, with both properties, I've built them to be fairly at max with what they can be allotted for as far as lot coverage. So the agreement that I understand is that both parcels more or less agree that you don't encroach further closer to either property. And I would honor that. But furthermore, I don't think that's an issue that would come up in the future because any ability to build more on those properties has kind of already been saturated, if that makes sense to you.
Any other questions from?
Through you, Mr. Chair, I guess I will look over to administration, put them on spot, say, what are you thinking of this?
To Mr. Chair, so we never like it when these types of mistakes are made. However, we had to look at it as though it hadn't been constructed. And as you can read in our report, we did find our way to support this through going through the 4 tests established in the Act. And then the site visit that we performed didn't reveal any concerns in terms of just the appearance in the real world situation. If you look along that street, it's a heavily urbanized area of the town. It doesn't seem out of place. So in addition to that, we felt that it met the intent of the OP and the zoning bylaw. And with respect to the OP, it's helping to facilitate an intensification of the property, an infill example. It meets the intent of the zoning bylaw, particularly with that condition with respect to the building officials being satisfied that there's the adequate measures put in place for buildings that aren't separated by the requisite amount in the building code. It's appropriate development for the area, and we believe that it's not going to result in any undue adverse impact, particularly given that the current property is owned by the applicant. So, yeah, these are tough because of the circumstances, but we ultimately decided that it can meet the 4 tests.
You done? I only have one question, and that is, how, you have foundation in the ground? What's the width of the house now?
Wall to wall, the interior width of the house is about 20 feet.
The outside of the foundation?
21, 22, close.
Okay, so you now have an extra 2 feet on the street side?
I don't believe so. No, the whole, like, I've still followed the parameters for what I was permitted to build. The only issue is that it should have been about a foot further north. So as far as side yard, you're referencing that I've got more side yard on the north side?
I just want to know that you're building, you gave us a drawing
Hmm.
the first time you were here. And you had a width of the house of 21.3 feet. So is it still 21.3 feet?
I've not deviated from the permit that I had approved other than my error here.
Okay. That's all. That's all I have. Paul?
We okay to make a motion?
Sure.
Well,
Anytime.
so listening to Mr. Jeffrey's recommendation, I guess forgiving the gentleman's situation and possibly our overlook. In my opinion, 1 foot is minor in nature. If everything falls into place on the ground, I make a motion to approve application A2624 901 St. Pierre, that it meets 4 tests and relatively matches the area.
We have a motion on the floor. All in favor? Moved by Paul and Dennis. Okay, everybody's in favor? Unanimous?
Yeah, just again, thank you. And sorry, I won't shake any of your hands because they're just sweating terribly because I'm nervous, but I appreciate all of you for being respectful to my mistake.
Is there any unfinished business? Is there any new business? Motion to adjourn? Paul and Tom. Paul and Tom. Adjourn? All in favor? Dennis. Oh. Anyway, thank you.